Hello students, I am Dr. Neha Kapoor Chawla. Today we will discuss the grounds for dissolution of marriage under Hindu law in our country. So let us start with the objectives of the module. The main objectives of the module are to understand the meaning of divorce under Hindu law. Secondly, to know the grounds of divorce available to husband and wife. Thirdly, to understand the grounds of divorce available only to the wife. Fourthly, to examine the essential conditions of each of the grounds of divorce under Hindu law. And lastly, to understand the judicial interpretation of the various grounds of divorce in Hindu law. Let us start with the introduction of the topic. In the first module on dissolution of marriage under Hindu law 1, we have discussed the concept of divorce, the theories of divorce, and the matrimonial remedies available to the parties to the marriage. Further, students, in this module, we will discuss the various grounds available to the husband and wife, both individually and collectively, under the Hindu Marriage Act 1955. These grounds are based on the fault theory of divorce and depict that whenever either the husband or the wife is at fault due to adultery, cruelty, desertion, unsoundness of mind, etc., the other party can seek divorce. In such cases, the court may, on an application by the aggrieved party, and when it is just and reasonable to do so, pass a decree of divorce between the parties. Further, the Hindu Marriage Act 1955 provides certain grounds to the woman only on which she can seek divorce, such as the grounds of second marriage by the husband when the first is subsisting, rape, bestiality, non-resumption of cohabitation, etc. These grounds are believed to protect the rights of women in case the husband breaches any of the conditions of marriage. Additionally, it is also important, students, to remember that divorce is a right arising out of marriage, and a party to a marriage can claim divorce when the marriage is valid in law, as it is presumed that the conditions of marriage are fulfilled in that case. Now, students, let us move ahead with the lecture on grounds of divorce. The Hindu Marriage Act 1955 under section 13, 13A, 13B, 14 and 15 lays down the provisions for obtaining divorce either by the husband or the wife, and also by the wife only. Firstly, we would now discuss the grounds available to both the husband and the wife. Let us discuss the first ground of divorce under section 13, that is adultery. Section 13, subsection 1, clause 1. Initially, adultery was only considered a form of immorality, but with the passing of the Marriage Laws Amendment Act of 1976, it was included within the grounds of divorce. The Hindu Marriage Act 1955 provides the first ground for divorce to be adultery. That is, if a spouse, after the solemnization of marriage, indulges in the act of sexual intercourse with a person other than the spouse, then he is said to have committed adultery. Now, students, it is pertinent to mention that the act of sexual intercourse must be outside of marriage and should also have been voluntarily done. So, any sexual relationship the wife committed before marriage would not constitute as adultery against her. Further, the fault theory of divorce is the genesis of this ground of divorce as well. Basically, marriage is a union of two individuals entered into for the purpose of cohabitation and recreation. The act of adultery not only leads to a criminal offense but also breaks the basic thread or the bond of marriage. Let us move on to the next subtopic, that is the standard of proof in cases of adultery. The standard of proof required in cases of adultery as a ground for divorce under the Hindu Marriage Act 1955 is the same as in civil cases, that is the preponderance of probabilities. Since adultery is an act committed in closed rooms, the availability of the actual evidence of it is extremely rare. Accordingly, it can be said that circumstantial evidence must be used to justify the fact that the act would have been committed. Thus, the burden of proof in such cases lies on the party alleging it, as there is a presumption of innocence in such cases. In the case of Har Gobind Soni versus Ram Dulari, the court held that the proof of circumstantial evidence of adultery must be such that a reasonable man would not be able to draw any other inference than the act of adultery itself. Now, students, we move on to the second ground of divorce under the Hindu Marriage Act, that is cruelty. Section 13, subsection 1, subclause 1A. The petitioner must demonstrate that the respondent's treatment has put their lives in danger or damaged their physical, mental or emotional health in order to support this ground for divorce. Though the term cruelty has not been defined under the Hindu Marriage Act 1955, the requirement of the clause is that it must be serious and gruesome in order to fall within the definition of cruelty. Since there is no definition provided under the Act, the circumstances included within it would be decided on a case-by-case basis. The word treated signifies a continuous course of cruel behavior by the respondent towards the petitioner. Further, it is not essential that there is always a direct act or action of commission of cruelty by the party. It can also be in the form of a silent conduct of a spouse, which causes a mental suffering or fear for the matrimonial life of the other spouse. It is pertinent to mention that cruelty must be distinguished from the ordinary wear and tear of life. That is, small quarrels between husband and the wife or a difference of opinion between the parties must not be classified as cruelty. Also, cruelty cannot be judged on the basis of the sensitivity of the petitioner and would in general be only examined from the facts and circumstances of each case, as held in the case of Savitri Pandey versus Premchandra Pandey. Likewise, in the case of Naveen Kohli versus Neelu Kohli, it was held by the Supreme Court that the well-established view that in order to constitute cruelty, the conduct complained of should be grave and weighty, so as to come to the conclusion that the petitioner's spouse cannot be reasonably expected to live with the other spouse. Again, in the case of N.C. Dastane versus Mrs. S. Dastane, the Supreme Court examined the concept of legal cruelty and held that the acts of tearing of Mangal Sutra, locking out the husband when he is due to return from office, beating a child mercilessly, switching on the lights at night, and nagging the husband are acts of cruelty. Now students, we move on to the next ground for divorce, that is desertion. Desertion is provided in section 13, subsection 1, clause 1b. The term desertion under Hindu law constitutes the act of abandonment of one spouse by the other. It is based on the requirement of a period of 2 years. That is, if the party to the marriage has departed from the life of the other spouse for a continuous period of 2 years, then the other party can file a petition for judicial separation or divorce. Further, students, it is important that such relinquishment by the spouse be without just and reasonable cause and also without the consent of the other party. Additionally, there is also the element of deliberately neglecting the duties towards the spouse. The essence of desertion lies in the fact that there is ignorance or complete repudiation of marital obligations by one of the spouses in a marriage. This denotes the total forsaking of cohabitation between the parties against the wishes of the other party, which is the very essence of a marital bond. For desertion to be proved, there must be a fulfillment of two essentials, that is, firstly, the actual or physical separation between the parties known as the factum of separation, and secondly, the intention to bring cohabitation permanently to an end, that is, animus disserendi. In order to constitute actual desertion, the following must be established. Firstly, the spouses must have been living separately. Secondly, the spouse leaving the other spouse must have the intention to do so. And thirdly, the spouse who has been deserted should not have agreed to be deserted. Fourthly, the abandonment should have been without a valid reason. And fifthly, a continuous period of 2 years must have passed since the desertion started. As a result, the Supreme Court stated in the illustrious case of Bipin Chandra versus Prabhavati that a wife would not be guilty of desertion if she leaves the matrimonial home without a reason, later expresses her intention to return, but the husband prevents her from doing so. This is so because in order to constitute desertion, students, it is mandatory that the deserting spouse have a persistent intention during the entire statutory period of 2 years. On the other hand, there can be cases where a party to a marriage may quit cohabiting with the other spouse in such instances where one spouse creates miserable conditions of living for the other spouse. It would not be desirable for the other spouse to leave the party. In fact, the party creating such conditions or circumstances for the other would be guilty of desertion. In legal terms, it is known as constructive desertion. That is, the situation where one party compels the other to leave due to the former's behavior or habits of living. Accordingly, in the case of Jyotish Chandra versus Meera, the court held the husband to be guilty of desertion, as he had by his conduct forced the wife to leave the matrimonial home. Now students, we move on to the next ground of divorce, that is conversion. Section 13 subsection 1 subclause 2 of the Hindu Marriage Act 1955. This section applies to the marriage of two Hindus only, and if one of the parties to the marriage ceases to be a Hindu or converts itself to another religion, then the other party can file for a petition of divorce. Although the abandonment of Hinduism does not primarily dissolve the marriage, it poses as a valid ground for judicial separation and divorce under the Act. In the case of Lily Thomas versus Union of India, it was held by the Supreme Court that renunciation of belief in Hindu religion and converting oneself to follow any other religion like Islam, Christianity, Judaism or Zoroastrianism can be grounds for filing for divorce under the Hindu Marriage Act of 1955. Now we move on to the next ground of divorce, that is unsound mind. Section 13 subsection 1 subclause 3. As we know that a sound mind is the first condition for a healthy and a happy life, it is equally important for both the parties to have a sound mind to be able to live together. Likewise, the Hindu Marriage Act 1955 recognized the unstable mental condition of either spouse as ground for divorce. The Act prescribes that in the presence of any of the symptoms in one party of an illness of the mind, such as the partial development of mind, mental attacks or psychopathic disorders, including schizophrenia, the other party in that case can seek the separation of marriage. Further, all mental disorders do not constitute grounds for divorce under the law. In the case of Dastane versus Dastane, the court ruled that only persistent mental impairment that results in aggressive, abnormal or irresponsible behavior by the party can be considered as unsoundness of mind. Even in the case of Ram Narayan Gupta versus Srimati Rameshwari Gupta, the Supreme Court held that unsoundness of mind requires an evaluation of the degree of mental disorder, and that should be to such an extent that the other spouse cannot be reasonably expected to live with the other spouse. Now students, we move on to the next ground of divorce, that is leprosy. Section 13 subsection 1 subclause 4. Under the Hindu Marriage Act of 1955, a party in a marriage could file for divorce if they contracted a serious skin or a nerve disease, but the Personal Laws Amendment Act of 2019 has removed it from the list of grounds for divorce. This is so because in India it is no longer a communicable, incurable disease and is now a curable illness. Also, due to the judgments of various courts declaring it discriminatory in nature, the Act was amended to repeal the provision. The next ground of divorce is venereal disease. Section 13 subsection 1 subclause 5. The presence of a sexually transmitted disease in a party to a marriage entails a ground of divorce for the other party. Also, it is important for the petitioner to prove that it is a disease in a communicable form and that he or she is not taking advantage of his own wrong within the meaning of the provision of Section 23, Clause A of the Hindu Marriage Act 1955. Thus, if the petitioner himself was suffering from the venereal disease and was the cause of transmitting it to the respondent, then he cannot get relief under this clause. The next ground of divorce available under the Hindu Marriage Act is renunciation of the world. Section 13, subsection 1, subclause 6. A person who has renounced the world can be said to have laid the groundwork for obtaining divorce. Abstention from worldly affairs is the exact opposite of the obligation of marriage, which has the primary characteristic of being a social obligation. Such a person who forsaked the worldly affairs is also known as a sannyasi, and he must perform the ceremonies necessary for the same. Such a person is also considered to be dead under the matrimonial law. The next ground of divorce, students, is the presumption of death. Section 13, subsection 1, subclause 7. Under this ground of divorce, if one party to marriage is not being heard of being alive for a continuous period of 7 years, then the other party to the marriage can seek divorce. This is so because the law considers such a person to be dead if the relatives of such a person or persons who have naturally heard of him have not heard of him being alive for 7 years. He is presumed to have died. The cause of death is immaterial in such a case. Such a provision allows the petitioner to remarry and have children in addition to the above. The following grounds of divorce are also available to both husband and wife under the Hindu Marriage Act of 1955. Firstly, the non-resumption of cohabitation after a decree for judicial separation. Section 13, subsection 1a, subclause 1. In cases where there is no revival of cohabitation between the parties, even after a time period of 1 year or more of the decree of judicial separation, any party can present a petition for divorce. Secondly, the failure to comply with the decree for restitution of conjugal rights. Section 13, subsection 1a, subclause 2. If a party to marriage fails to comply with the decree of court for restitution of conjugal rights within 1 year of such a decree, the other party would be entitled to a decree of divorce. Next, students, we come to the additional grounds that are available to the wife under the Hindu Marriage Act for obtaining divorce. First is bigamy, 13 subsection 2. A wife may also file for divorce if she finds that the husband has married again after the solemnization of their marriage, and the other wife must be alive at the time the petition is filed. Secondly, rape, sodomy or bestiality, section 13 subsection 2, subclause 2. A wife may also present a petition for divorce if after the marriage the husband has been found guilty of rape, an unnatural sexual offense. Thirdly, non-resumption of cohabitation after decree or order of maintenance. Section 13 subsection 2, subclause 3. A wife may also present a petition for divorce if the husband has not supplied maintenance to her even after the decree of the court, and also a cohabitation between them cannot be resumed for a period of 1 year or more. Fourthly, option of puberty. Section 13 subsection 2, subclause 4. The woman under Hindu law has been given a right to present a petition for divorce if her marriage took place before she was 15 years of age and she revoked the marriage after attaining the age of 18 years. This option would be available to the wife even when the marriage was consummated. Next, students, we move on to the alternative relief in divorce proceedings. Section 13A of the Hindu Marriage Act 1955 provides that in any petition for divorce, if the court is satisfied that it would be just and proper to pass a decree of judicial separation between the parties, it can do so, having regard to the circumstances of each case. This provision shall not apply where a petition is made on the grounds of conversion, renunciation of the world, or presumption of death. Next, students, we move on to the divorce by mutual consent under the Hindu Marriage Act 1955. Section 13B. This ground is based on the mutual consent theory of divorce and provides that if both parties to a marriage with each other's consent decide to dissolve the marriage, then they can apply for a divorce under this clause. In such a case, it is vital to prove that they have been living separately for 1 year or more and have not been able to live together. The court may, within a minimum of 6 months and a maximum of 18 months, and after conducting an inquiry, pass a decree of divorce. As per section 23, subsection 1, clause BB of the Act, the court must evaluate whether the consent of the parties has not been obtained by fraud, force, or undue influence. Then no petition for divorce is to be presented before the expiration of 1 year of marriage under section 14 of the Hindu Marriage Act 1955. In order to prevent parties from making hasty decisions, the law provides that a petition for divorce cannot be obtained within 1 year of marriage. Though the court may, in exceptional cases, consider the petition and also take into account the interests of the children in such marriages. Now, let's come to the conclusion of today's lecture. Thus, in this module on dissolution of marriage under Hindu law 2, we discussed the various grounds of divorce available to both husband and wife as well as to the wife. The existing jurisprudence on the topic has been explained with the help of decided cases. Also, it is important to note that subsequent rights and duties of parties arise after the decree of divorce, such as the maintenance of the wife and children under section 125 of the Criminal Procedure Code 1973 and the custody of children, including illegitimate children, as they are equivalent to legitimate children. With this, we come to an end of today's lecture. I hope you all have enjoyed the lecture. Thank you very much.